Welcome, everybody. My name is Paula Price. I'm with the People's Law School, and we're here today for a webinar, What You Need to Know About Changes to the Divorce Act. And we've got our guest, JP Boyd, QC, and I'll be introducing him more formally in a few minutes. First, we're just going to run through a little bit of information about what you can expect today. Today, we will have 60 minutes together. And over the next 60 minutes, we will answer common questions about the changes to the Divorce Act. We will be providing legal information, not advice. And that information is current as of today, effective March 1st, really. And if what you're seeking is legal advice as opposed to legal information, then we would encourage you to reach out to a lawyer to do that. You're also welcome to contact our speaker, and the information is on the screen. Now we're almost ready to introduce our guest speaker. I know you're all really excited, so am I. But before we do that, we want to acknowledge, make a few acknowledgements. First of all, I would just like to begin by acknowledging that the land on which the People's Team is gathered is the unceded territory of the Coast Salish peoples, made up of the Musqueam, Squamish, and Tsleil-Waututh nations. People's Law School acknowledges the financial support of the Department of Justice Canada and the Law Foundation of British Columbia for the production of this webinar. We would like to acknowledge all of you for being here today, the members of our community and our public who join us for our webinars. You are the reason that we do these, and we're delighted to have you here today. And we thank you for your time and your attention. And last but not least, we would like to thank our speaker, John Paul Boyd, QC, who joins us from Calgary, Alberta. JP is a family law arbitrator, mediator, and parenting coordinator. He's also a member of the Law Societies of British Columbia and Alberta. He's got a practice that spans both provinces. And as I alluded to earlier, JP has produced a wealth of information, and so much of it is available online. And I wanted to just highlight a few of those for you. One is a wiki book on family law that's available on the BC Courthouse Library website. He's also created a very lovely collection of videos on his YouTube channel. So and we'll provide links to this, but there are all these wonderful videos, varying in length. Some of them are 5-minute clips, some of them are up to an hour or more. And he covers all sorts of topics about family law, including changes to the Divorce Act. So I encourage you to check that out if you're looking for more information, particularly about the changes to the Divorce Act. One last thing that I'll mention is he was the legal reviewer for some of the Dial a Law pages that we have, that members of the People's Law School team have prepared in regards to the changes to the Divorce Act. And so we're very grateful for the work that he's done for us, and we are excited to have him here today. So JP, after all that, welcome. It is so nice to meet you.
Well, thanks, Paula. Nice to meet you as well.
Fabulous. And how are you doing?
Well, I'm enjoying the snow we've got here. Well, I'm sure the daffodils are coming up in Vancouver. So we're doing well, though. We've just left a horrific cold snap, not as bad as Texas, I assume, but we're all surviving anyhow. But I'm very glad to be here and to be talking about this new change to the Divorce Act.
Fabulous, fabulous, JP. And we're so excited to have you here. So we're going to jump into the questions. And the first question that we have for you, JP, is, the Divorce Act hasn't changed much in 35 years. Why now?
Well, so that's a complicated question, but I think that basically what's going on is that the provinces have led the charge, starting in Alberta in 2005, carrying on to British Columbia in 2013. Nova Scotia got into the act in 2015, and Ontario is just coming online with new ways of figuring out how we talk about children and new ideas about where the focus of the rights are when we talk about parenting after separation. Is the focus on the rights of parents and their entitlements, or is it more about children and children's entitlement to be parented properly and given the best possible care after their parents have separated? So that's a big change. Another big change that we're seeing is also starting in the province are changes about how we think about family violence and the role that family violence needs to play and should play in decision making after parents have separated. And so I think that what's going on is we have divorce legislation that has, quite frankly, gotten rather stale. And it's beginning to fall behind the curve in terms of where the majority of provinces are thinking about children and about family violence and about really complicated issues like about relocation after parents have separated. So that's kind of the nuts and bolts. And you can see all of that reflected in some of the amendments that are being made to the Divorce Act.
Fabulous, thank you. And that leads to our next question, which is, what are some of the changes that we're seeing in the Divorce Act?
Well, the changes are big in some ways. The biggest changes really have to do with the language that we use to talk about parenting after separation. That's a big one. I'll talk about that in a second. Another big new change is about how we deal with what should happen when a parent wants to move away after separation. And that's because there's a very old Supreme Court of Canada case. It's not that old, really. It's called Gordon and Gertz. It's from the mid 90s. And that was a hugely important case because it set the law for all of Canada about how we make decisions about parents who want to move away with or without a child after separation. The problem, though, is that the more time passed, the more that test in that one Supreme Court of Canada case got bent out of shape so that the certainty it once provided to parents who want to move is now completely lost. And so the new test that we see not only in the Divorce Act, but also in other provinces, including the new legislation in Nova Scotia and the new legislation in British Columbia, all are just trying to provide guidance and more certainty and insight for parents who are thinking about moving away after they've separated. So that's a big one. Another big one is the test, talk about parenting after separation and the best interests of children. And we'll talk about that in a few slides later. And finally, there's this business about new duties that parties, lawyers, and judges have. The most important new duties for parents include an obligation to try to resolve your disputes other than through court. That's really important. Everybody needs to understand that litigation is not your only option. There are other, better, faster, and cheaper solutions available that include things like collaborative negotiation, mediation, and even arbitration. So parents need to think about that. There's also a brand new duty that requires parents to do what they can do to protect their children from the conflict arising from their legal dispute. And another new duty is that parents have to provide each other with the information that they are entitled to help them make decisions about things like parenting after separation, child support, and spousal support. And that's all because there's a certain number of, cluster of folks who sometimes, don't cough up the income tax return information and the other income information that's needed to help the court and other people make decisions about child support. So some really new important tests there. And then from the judge's point of view, the most important new duty that the court has is a duty to think about when it's making decisions about children, to think about other orders and other court processes that are going on in the context of child protection and in civil protection orders and criminal matters. And that's really important because too many judges were making decisions accidentally about parenting after separation, custody, and access without realizing that there were simultaneous criminal proceedings going on, possibly involving a parent and a child, but more typically a parent. And so decisions were being made without the full benefit of all the knowledge available to them. And we saw a change to this effect in British Columbia with the Family Law Act. When it came into effect in 2013, there was a brand new rule that said that parents cannot agree to appoint somebody who is not a parent as a guardian. Only the court can do that. But the parts of the Family Law Act that talked about that required the required somebody who wanted to be a guardian to provide an affidavit that disclosed their full criminal record check, their full child protection record check, and as well a civil protection order registry check. So all of that was really important. And it's all about making sure that decisions about children are being made with the best possible information.
Fabulous. So it sounds like there's a lot of changes that are really promoting, as you just said, the best interest of the child. And we're all looking forward to hearing more about what that sounds like. Sounds like there are a number of problems, like the uncertainty that you mentioned with relocation, that is being addressed. This disclosure of information is being addressed. So it sounds like these changes are really responsive to some of the challenges that families have had in the past, and
Yeah.
that this will provide more clarity and certainty going forward.
Yeah, I mean, in a nutshell, society is different now than it was in 1985 when the current version of the Divorce Act came into effect. There's been a lot of change. But a
Absolutely.
whole bunch of things aren't changing, and that's really important too. So don't freak out because it's not a complete overhaul. When British Columbia got its new Family Law Act in 2013, that was a stem to stern renovation of the entire law on families separation in British Columbia. This is not quite so bad. So the things that aren't changing include the rules about separation and applying for a divorce, the rules about child support and children's special and extraordinary expenses, the rules about spousal support, and other things, including the rules about appeals. So the basic changes, again, just to refresh everybody, really concern the new duties that parents, lawyers, and judges have, the changes to how we talk about the best interests of children, how we talk about the rights involved in parenting after separation, and the new test for relocation. But the other things the Divorce Act covers, they're staying the same.
Excellent. Thank you so much, JP. So here's a question for you, a scenario that sounds something like what we might receive at the People's Law School. My unmarried partner and I have been together for the last 8 years. We have a 2-year-old daughter. Does the Divorce Act apply to us?
Quick answer, and the answer is no, because the Divorce Act only applies to people who are married to each other or who used to be married to each other. So if you're not a married spouse, then the Divorce Act doesn't apply to you. So if you're in an unmarried relationship, whether it's a living together relationship or something very brief that maybe just produced a child, the law that applies to you is the law of the province or the territory in which you live. So, for example, if you live in Alberta, the law that applies to you is the Family Law Act. In Ontario, it's the Children's Law Reform Act. In Nova Scotia, it's the Parenting and Support Act. So you need to be looking at the provincial or territorial legislation where you live if you're not married to your other partner.
Excellent. And this is a bit out of left field, JP, so forgive me. But if you're married outside of Canada and you relocate to Canada, are you considered to be subject to the Divorce Act?
Oh, absolutely, because the test is whether or not you're married. It doesn't matter where you got married or how you got married. If you're married, it's the Divorce Act.
Excellent. Thank you. So here's another question for you. My wife has told me that she wants to divorce me and take our 4-year-old twin boys with her. What does what does the new Divorce Act say about who gets the kids?
Okay, so in a sense, the answer to this question isn't really any different than the 1985 Divorce Act, the old Divorce Act, the one we have now, right? The Divorce Act, new and old, doesn't contain any preferences in favor of one particular parent over the other based on their gender, their age, their race, their creed, their color, their religion, or anything like that. What the Divorce Act instead talks about these days, and this is where I'm going to spend a little bit of time talking about the new language that we used. Firstly, and most importantly, we've got rid of words like custody and access to describe the arrangements made for parenting after separation. The problem with that old language is that it kind of had the feeling of a property right, that your children were your possession, just like your car or your house. And there was a black and white flavor to everything, which kind of pushed parents into arguing about these things in court quite vigorously. And even though the law kind of softened as time went on, you know, custody still kind of felt like a property right. And if you didn't have custody, you felt like you were less of a parent after separation. So the new changes get rid of custody and access. And instead, we talk about spouses who have parenting time with their children and spouses who have decision-making authority over their children. And then we talk about people who aren't spouses who might spend time with kids, and what they have is something different. It's called contact. So parenting time, and I love the choice of language, because parenting time, it's an activity. It's the time when you are engaged in the business of raising your children, right? It doesn't have the same drive-by flavor that kind of access sort of have. So if you're a spouse and you have a schedule of time with your children, you have parenting time. As a spouse, you probably also have something called decision-making responsibilities. And the Act doesn't contain any presumptions about how parenting time is supposed to be split up. It could be 50-50, it could be something different, like every other weekend, or maybe a 3-4 split or some other kind of arrangement. And it also doesn't talk about how spouses are supposed to share decision-making responsibilities. What I think is going to happen is that most of the time, most spouses will share those decision-making responsibilities. And that's the responsibility for making important decisions in a children's life about where do they live, who do they hang out with and associate with, where do they go to school, if they get sick, how are they treated, if they're raised in a religion, which religion, what's their cultural background like, what kind of linguistic instruction should they have. And most of the time, I think, spouses are both going to have decision-making responsibilities, which means they have to talk to each other about what those decisions should be and exercise that responsibility in the best interests of their children. Now, somebody who has contact is, generally speaking, not going to be a spouse. That's almost always going to be the case, but not universally. And the important difference between somebody who has contact and a spouse who has parenting time is this. If you have parenting time or decision-making responsibility, you have the right to make day-to-day decisions when the children are with you. You also have the right to ask for and receive information about the children's well-being, education, and health from anybody who happens to have it. On the other hand, if you're a person who has contact with a child, you don't have the right to make day-to-day decisions on behalf of a child when they're with you, and you don't have the right to ask for or receive information about the children's well-being. But what the new Divorce Act says about who gets the kids is all dependent upon the decision that's in children's best interests. And we'll talk about that on the next slide.
Fabulous. Thank you. Thank you very much, JP. I think that's really really helpful to clarify these different types of decision making, the day-to-day decision making, as opposed to what you refer to as the decision making authority or decision making responsibility. Sounds like they're very different levels of decision making, and also clarifying contact versus the parenting time. So that's all really interesting. Here's our next question. I'm worried about my sister. I think her husband is abusive toward her and their children. Does the new Divorce Act talk about abuse?
Yes, it does. And it does that in the context of how the judge makes decisions about the course of action that is in children's best interests. In the old Divorce Act, the current Divorce Act, it says at section 16 that the only thing the court can think about when making decisions about parenting after separation are children's best interests. But the Divorce Act didn't really explain anything about how you decided what was in children's best interests. The only thing that the Divorce Act contains that sort of gave any other additional information was at section 16, subsection 10, which said that the court, when it's making orders about access, should make an order giving the children as much time with each parent as is consistent with the children's best interests. Well, that was one of the main reasons why the Divorce Act kind of butted heads with a lot of the provincial legislation, because all you have to do is look at the legislation in Ontario, Saskatchewan, Manitoba, Alberta, British Columbia, Nova Scotia, New Brunswick, all over Canada. And you'll see that the legislation talked in a lot more detail about all the different things that the judge should be thinking about when making decisions. So this is one of the key changes to the new Divorce Act. So section 16, subsection 1, still says the only thing the judge can think about when making decisions about kids is kids' best interests. Subsection 2 says that there are 3 primary considerations, and what it says is this. When considering the factors referred to in subsection 3, and we'll get there in a second, the court shall give primary consideration to the child's physical, emotional, and psychological safety, security, and well-being. Okay, so far so good. Only their best interests, and then there are these three primary considerations. But then in section 16, subsection 3, there's a whole long list of all these different factors. And the factors are there to give a hand to the judge when making decisions about kids, but they're also there to help parents decide what they need to be thinking about. So the factors that are listed in section 3 include things like the child's needs in light of the child's age and stage of development, the nature and strength of the child's relationship with each spouse, and then the other important people in the child's life, like siblings and other family members and things like that. Each spouse's willingness to support the development and maintenance of the child's relationship with the other spouse, the history of the child's care, the child's views and preferences. But then is the factor any family violence and its impact on things including the ability and willingness of any person to care for and meet the needs of the child, and the appropriateness of an order that would require people to be able to cooperate on issues affecting the child. So this is immensely important. Legislation in Alberta and British Columbia has talked about family violence in the context of children's best interests for years, but the Federal Divorce Act didn't. It was silent on the issue. So this is significant because finally we have legislation about parenting after separation that requires the court to think about this on a national scale. And the other important thing is how the Divorce Act talks about what family violence is. In the very beginning of the Divorce Act, there's a section that contains a whole list of definitions about terms like decision-making responsibility and parenting time and who's a spouse and who's not and so on. But it also defines what family violence is. And it has a really broad definition that talks about family violence in terms of physical abuse, sexual abuse, psychological and emotional abuse, and financial abuse, as well as in some circumstances, attempting to abuse someone. So family violence has a really big definition, and it's appropriate because family violence isn't limited just to instances of physical abuse. So remember what we were talking about in terms of the best interests of the child test. Section 16, subsection 3 of the Divorce Act includes among that long list of factors family violence and its impact on a child's well-being and on the ability of spouses to care for their children. The Act also says that, well, when family violence is a factor, the court should look at these additional factors, a shorter list, but still another list of some additional factors that the court needs to think about. And those factors include the nature, seriousness, and frequency of the family violence, as well as whether the violence constitutes a pattern of coercive and controlling behavior. And there's a whole bunch more that you should look at. But the answer to this kind of quick question is that abuse is a factor. It's a factor that the court needs to think about when making decisions about the best interests of children, and it's one of the specific factors listed at Section 16 of the Divorce Act. And when family violence is a factor, the court has to look at an additional list of factors found at Section 16, subsection 4 of the Divorce Act. So this is all really important, and if family violence is a factor in your relationship, it's important that you read Section 16 very carefully.
Fabulous. Thank you so much, JP. I appreciate you really highlighting that this test exists to determine what is in the best interest of the child. And also your point that it's not just a test that judges will look at when applying the law, but also using this as a guide for parents, that they can actually look at this legislation themselves. They can see for themselves what the courts or what the legislature has determined are, these are the criteria that we're going to be considering to see what is the best interest of the children, because that's really helpful information to really get your mind wrapped around that. So thank you for that. Here's our next question. Once we deal with the divorce, I want to move with our teenage daughters back to Ontario from BC so I can be closer to my parents. Can I do that?
So this question is all about what judges and lawyers and legislators call relocation. We also call it mobility, but the most common way to talk about this is about moving after separation. And remember that case I was talking about that was important when it was released, but over time, as so many cases have relied on that case, it's gotten so bent out of shape that it's really stopped providing any helpful guidance at all. So what the Divorce Act says is this. First of all, there's another important definition, and that's the definition of relocation. And the Divorce Act defines relocation as a change in the residence of a spouse or a child that will likely have a significant a significant impact on the child's relationships with other people, including the other spouse, including siblings, including family members, and other adults who have an important role in the child's life. So what that means is that a move that isn't going to upset an existing schedule of parenting time will probably be just fine. So it might be moving from Surrey in British Columbia to Richmond in British Columbia, or moving from the south of Calgary to the north, something like that, where the existing schedule of parenting time can still continue. But moves that are longer than that are much more likely to have a harmful impact on the child's relationship to the other important people in the child's life. So when somebody wants to move away with or without their child, and the move is going to have this impact on a child's relationship, the new Divorce Act requires that for the person who wants to move to give written notice to the other person of their intention to move. They have to give that notice at least 60 days before the proposed move date, and the notice has to be in writing. It has to specify the date of the proposed move. It has to talk about the child's new contact information about where they're going to be moving to, and it has to contain a description of how the parent proposes that the current arrangements for contact, parenting time, and decision-making responsibility can still work if the move is allowed to happen. So that's really important. And the federal government has created a new form available on the website of the Department of Justice that is specifically to help people give that kind of written notice. Now, if you're the person on the other end of that notice, you have 30 days to object to the potential relocation. And you can make that objection in one of two ways. Firstly, by applying to court for an order stopping the relocation from happening, or secondly, by filling out your own form that expresses your objection to the relocation. That form is also available on the website of the Department of Justice. So this is really important because if you get your notice that somebody's planning on relocating and you don't object, they're able to go. But there's another really important distinction. The people who are entitled to notice of a relocation are people who have contact with a child, people who have parenting time with a child, and people who have decision-making responsibilities for a child. But it's only people who have parenting time or decision-making responsibilities who are entitled to object. If you just have contact, you're entitled to notice about the move and to get it in writing with all of the other criteria that are there in the act, but you don't get to object. So it's really important to say, hey, I don't agree with this, and file that objection. That's super important because if you don't, you risk the possibility that your spouse may be able to just move with or without your child. The other important thing is that the test is more complicated. And when the court is being asked to make decisions about a relocation that is objected to, it has to consider all of the best interest tests at Section 16 of the Divorce Act, as well as some new factors that appear at Section 9.16.9 2, 3, or 4, somewhere around there. But there's an additional list of factors that the court has to think about, such as the reasons for the move, the impact that the move is going to have on the child's relationship with the people who are staying behind. Another factor is whether or not the person who wants to move complied with the notice requirement. And then it gets a little more complicated because there's a question about which spouse bears the burden of proof. And that's a complicated legal term, but what burden of proof means is it means who's responsible for proving what. And the burden of proof when it comes to relocations shifts. If the child's time is divided between the spouses more or less equally, then the person who wants to move has the obligation to prove that the move is in the child's best interests, thinking about those factors in Section 16 and the additional factors that the court has to think about when somebody wants to move. On the other hand, If the parent who wants to move has the child for the vast majority of the child's time, then it's the other person, the objecting person, who has the burden of proof to show that the relocation is not in the best interests of the child. And in those middle cases between vast majority of the time and a substantially equal amount of time, both parents share the burden of proof to prove either that the move is or is not in the child's best interests. So there's no good answer to the question of, my partner wants to move back to Ontario or from BC to be closer to the parents. Can I do that? It's actually a lot more complicated. Depends on the best interests of the child, the additional factors that relate to moving, and who bears the burden of proof.
Fabulous. JP, that's really helpful, and we'll provide links to the forms that you described. And it sounds like there's that really interesting category. There's the one that you mentioned, the after best interests of the children, the reasons that the court will consider. So I imagine those might be if you have a job somewhere, if you want to be closer to family.
Yeah.
What kind of factors do you think will fall into that category?
Well, those are all really important. And typically people who want to move, I mean, people don't do this frivolously, right? It's usually because of a new relationship, a new marriage. It's because of an employment opportunity or a healthcare opportunity or educational opportunity that's only available in the other place. Sometimes people want to move because after separation, they need more support from friends and family. So that's another reason to move. But there's one factor that the court is not allowed to think about, and that factor is whether the person who wants to move would still move if the child wasn't allowed to move with them.
Interesting. Thank you for that. Okay, so we're on to our next question. My wife and I have been separated for 9 months, and we've got a few questions here. I'll just read them out and then I'll turn it over to you, JP. So one question is, when can we file for divorce? Do we need a written separation agreement? And finally, when should we start dividing our assets?
Well, I have some really good news because none of this is changing from the old act to the new act. As far as filing for divorce is concerned, you can file for divorce as long as you have lived in your present province or territory for at least 12 months before you file the divorce claim. As far as asking for the divorce, in other words, asking for the order, it has to be 1 year since the date of separation. But as long as you've lived wherever it is that you're living for at least 1 year, you can file for divorce as soon as you've separated, whenever you feel like it. Do you need to have a written separation agreement? No, you don't. This is important because it's important to understand that no one can force you to sign a separation agreement. It's not required by the law, although honestly, as long as you can work them out fairly, these things are a good idea, because a separation agreement is a contract, just like the contract you have with your employer or the people that you lease a car from. And a contract signifies that you and your spouse have managed to reach an agreement about all the things that you talk about in your separation, such as child support, spousal support, parenting after separation, that's parenting time and decision-making responsibility, or about how your property and debt are going to be divided. But the court doesn't have that kind of a supervisory kind of role. It's not going to act as a gatekeeper and stop you from getting divorced if you don't have a separation agreement. It's a good idea to have one because you do want everything to get wrapped up, but it's not a necessary prerequisite for getting a divorce. That last question about when should you start dividing your assets? Well, again, you kind of want to have that agreement in place before you start deciding who gets what. In general, when lawyers work with spouses to deal with the fallout from the end of a relationship, we try to talk about everything all at once. It's possible to wrap things up separately so that you might have, instead of a separation agreement that does a stem to stern discussion about everything, well, you might have an agreement about parenting or an agreement that just talks about support. So you can do agreements in sort of a piecemeal kind of basis. But in general, we want to wrap everything up at the same time. And the reason is that issues about spousal support, for example, sometimes have a relationship with how property and debt are dealt with. And we just never know. So In general, it's a good idea to hold off on actually transferring property around and deciding who gets to keep the car and who gets to keep the box set of Kenny G albums until after you've dealt with all the other issues. And so that would be my strong suggestion, but it's just a suggestion. You don't have to.
Fabulous. Thank you very much, JP. So our next question here is, I have an order under the old Divorce Act that gives me sole custody of our daughter. Do I need to go back to court to update it?
Okay, so this is really, really important. Okay, so the key thing about the new Divorce Act compared to the old Divorce Act, as far as this presentation is concerned, is that we're using really different language to talk about parenting after separation. So the question that this asks is about, what do we do with all of the old orders, old agreements, and old arbitrators awards that use Divorce Act language on the old Divorce Act language? So first of all, really important thing, you don't need to worry. You don't have to go back to court or renegotiate your separation agreement or go back to your arbitrator. The old agreement, order, or award will continue, and it's just as important now and just as binding on you now as it was then. But there are some rules you need to know about how to translate the old to the new. So basically, if you have custody under an old order, agreement, or award, you now have decision-making responsibility. If you are a spouse and have access under one of those old documents, you now have parenting time. And the fun thing is that if you're a spouse who has the primary residence of your child, you probably don't have a schedule of access set out, but you also have parenting time. Your parenting time is the time that the child is with you and not with the other spouse. Finally, if you are not a spouse and have access to a child under the Divorce Act, you now have contact with a child. And remember that the big difference between contact and parenting time is that parenting time is usually something that only people who are spouses have, although there are exceptions to that. Somebody who has contact is most of the time not going to be a spouse. But the big difference in terms of what those things mean is that somebody who has parenting time has the right to make day-to-day decisions about the child when the child is with them. They also have the right to ask for and get information about the child's well-being from anybody else who happens to have it, including the other spouse, doctors, teachers, dentists, and all the rest. Somebody who has contact only has the entitlement to spend time with the child. They don't have day-to-day decision-making responsibility, and they don't have the right to ask for or get information about the child from other people.
Excellent. Thank you, JP. So this is a great time for us to transition to the live questions. So I'm going to stop sharing my screen and turn to the Q&A and start from the top. As I do that, I do have a question that came in from one of our guests before the webinar, and that is, how much does a divorce cost?
Well, so a divorce is the costs involved in getting a divorce are about court fees, and they're also sometimes about lawyers' fees if you choose to have a lawyer help you get divorced. You don't have to hire a lawyer to get divorced, okay? You can do this on your own. It's complicated, but resources such as my wiki book published by Courthouse Libraries have a step-by-step process that'll guide you through it. But essentially, it costs somewhere in the neighborhood of $230 to file the claim you have to file to ask the court for a divorce. And an important footnote here is that you don't get divorced by agreement. A court has to make an order. So that means that you've got no choice except to start a lawsuit claiming a divorce. And the only court that's able to hear Divorce Act claims are Canada's superior courts. So in British Columbia, that's the Supreme Court of British Columbia. In Alberta, it's the Court of Queen's Bench. It's the Court of Queen's Bench in Saskatchewan and in Manitoba. In Ontario, it's the Ontario Superior Court of Justice, and I think it's the Supreme Court of Nova Scotia, and the names change depending on where you are. But it's only the higher trial court that can make divorce orders. So in British Columbia, the cost to file the claim asking for a divorce is about $200 plus another $30 to file for the doesn't matter. It's about sending a form off to Ottawa to let the Central Registry of Divorce Proceedings know that you're getting divorced. So there's that first fee. And then your spouse needs to be personally served with the filed court document. If you are doing it together, you don't have to spend that money. But if you're doing it separately, the person who wants to get divorced has to pay for that. And the fee that gets charged for it, because you can't do it yourself, is going to depend on the fees charged by that process server. But you can probably expect to spend maybe $100, maybe $150 on that. And then finally, after you've paid the fee to file the court form's been served on your ex, then you actually have to apply for the court order. And the cost for that is about $80. So all told, you're looking at a bill of slightly less than $500. If you want to buy a kit that has all of these pre-printed forms that you just fill out on your computer, that's probably going to be another $60 maybe. And if you pay for a lawyer to do it for you, most lawyers will charge you a flat rate if all you're asking for is just a divorce. And the flat rate, usually starts maybe $1,000, maybe $1,500, but it will go up depending on the other issues that are involved. So what I used to charge was $1,500 for a basic divorce, but maybe $2,000 if you had kids, because if you have kids, I have other paperwork that needs to be completed. But you can do it yourself, and you can do it yourself for maybe less than $500.
Okay. And I gather, JP, that's in the case of a non-contentious divorce. If you start getting into a
Oh yes,
situation.
we're talking about a situation where nobody's objecting, where all you want is just getting a divorce, or you want the divorce, but all the other orders about child support or spousal support, parenting after separation, the division of property is all being done by agreement.
Okay, and I gather that's a pretty, it can be a very substantial amount for parties that do end up uh, really having to engage in the court process,
Oh,
having the
what?
various applications.
Yeah.
And I'm not asking for an estimate, but
Oh, no, but it's important for everybody to know that if you choose to try to resolve your disputes in court, and sometimes, by the way, that makes sense. Sometimes it makes sense to go to court because somebody's making threats to harm you or your child or your property. Sometimes you have to go to court because there's been a history of family violence. Sometimes you've got no choice except to go to court because somebody's refusing to cooperate or refusing to give you important financial information. So in cases like that, you may have no choice but to go to court. But here's the thing, something like only about 5% of all family law cases get resolved at trial. That means that the rest of them all get either dropped or resolved by people's agreement. But if you do have to go to court for whatever reason, I'm not judging anybody, but if you do, be aware that you're not going to get out of court spending less than $20,000, and the bill only goes up from there. Your bill will go up depending on how hard it is for you and your spouse to reach an agreement, depending on the cost on an hourly basis of the lawyers that you each hire, on the number of issues you resolve, on the number of times you have to appear in court, on to get temporary orders before your trial comes around. And then the trial itself. I mean, here's a quick snapshot. In general, lawyers work 10 hours a day for every day of the trial, and they work an equivalent amount of time to prepare for the trial. And that's not talking about the year and a half, maybe 2 years worth of pre-trial activities that go on. And so if you think about that, the bill adds up really quickly. And on top of that, the court charges a per day trial fee that goes up the longer your trial is. So I have seen bills to clients that would, make your jaw hit the floor. So if you can resolve your dispute outside of court, you really should try.
As a former litigator, I agree. Um, one um, one thing I understand, I think you either mentioned it earlier in this webinar, or it was one of the webinars I watched you speak on just the other day. You had mentioned the duty of, in fact, I think you mentioned it today, the duty of lawyers to advise their clients of their out of court options. And so if you were to take one of those routes, of what type of options are available and what would be the cost difference from your perspective between that and
Right.
say doing
Well, when I just so everybody knows, I worked as a litigator and mediator and an arbitrator in Vancouver for about 14 years before I left to go to Calgary to run the Canadian Research Institute for Law and the Family at the University of Calgary. And one of the bits of research we got to do there was a national survey of family law lawyers, asking them for their opinions about the different ways that we have to resolve family law disputes. And what we asked them about were mediation, where the parties go see a mediator who helps them talk to each other but doesn't have the power to make a decision. Collaborative negotiation, which is a process where each person hires specially trained lawyers who all agree to work together to resolve a problem. Arbitration, which is where you go to hire a lawyer to make a decision for you. And then finally, litigation, which is going to court. And the lawyers who responded to our survey, and there were something like 150 of them, they largely agreed that every process was half as much money and twice as fast as resolving disputes in court. They also said that every way other than litigation was more likely to result in a long-lasting settlement that was more likely to be in the interests of their clients and in the interests of their clients' children. So in general, all of these processes, mediation, collaborative negotiation, and arbitration, are going to cost you less than half what you would pay to resolve a dispute in court and take less than half the amount of time.
Fabulous. Thank you very much, JP. I'm going to turn to some of the questions. There's one about the mobility test, but I'm going to ask a couple before that about children in particular. If this is going to the family violence, if the spouse found to be guilty of violence against the wife in the presence of children aged 18 months and 3 months old, is the father still entitled to parenting time after separation?
So here's the thing. As a spouse who has kids, you're entitled to ask for parenting time and you're entitled to ask for decision-making authority or responsibility. Most of the time, the court is going to reach the assumption that you should have some time with the kids and you should have some responsibility. And parents who get along well with each other and parents who are good parents, who are, skilled at the business of raising children, can expect they're probably going to wind up having maybe an equal distribution of parenting time, and that they're all going to share all of the responsibilities associated with making decisions for kids. But a parent, though, who has committed family violence, and assuming that the court goes through all the steps where it looks at the special family violence factors at section 16, subsection 4 of the Divorce Act, well, they might have restricted time with the children. And one of the options available to the court is to make an order for parenting time that is conditional upon a spouse doing or not doing something, or an order for parenting time that is supervised by somebody else. So in a case involving family violence, supervised parenting time might require that the spouse's time with the kids be held in the presence of somebody else, the parent's own parent, for example, or another family member, or maybe be held at a professional supervising service, because they exist, where the parent's time with the kids happens under the watchful eye of somebody who's trained to sort of do this kind of thing. The conditions that might be applied might be you can't see the kids until you've completed a family violence training course, or anger management, or some other therapy intended to address the family violence. But if there's anything that sort of needs to be said here, it's this. Family violence is an important factor that the court will take into account when it's making decisions about parenting time or contact, and about the contact that each spouse needs to have with each other to exercise parenting responsibilities, decision-making responsibilities. But there's no guarantee, nor should there be, that that parent won't have any time with the kids at all. There was usually, probably, most of the time, going to be some contact, but the nature of it depends on the severity of the violence and all the other factors that you see at section 16, subsection 4.
Super. Thank you very much, JP. That's really helpful. We have another question here. What age in BC can children decide with whom they would like to live?
Oh, this is a question that comes up a lot. And people have an idea that there's some magic age when kids suddenly are empowered to make the decision about, I'm going to live with mom all the time, or I'm going to live with dad all the time. And that isn't the case. The only magic age really is the age of 16 in most provinces, but not all. The reason why 16 is the magic age is because 16 is the age at which the child protection authorities will not drag the kid kicking and screaming back to your house to live with you if they run away. After age 16, the child protection people are going to probably put the child up in a hotel or even worse, in a foster home. So there really is no magic age when kids get to make up their minds. But the older children get, the more and more the court will take into account the children's views and preferences. And remember that there's that part of section 16, subsection 3, on that long list of best interest factors, which includes the child's views and preferences. But the views and preferences of a 3-year-old are going to be considered with much less weight and persuasion than the views and preferences of a 13-year-old. So it's all going to change, but there's no magic age.
Fabulous. Thank you. Here's another question for you, JP. Will there be enough arbitrators and mediators to facilitate using those options without facing extremely long waiting periods? And are the parties allowed to skip that duty and go to court if there are no arbitrators and mediators available?
Okay, so let me turn to the part of the Divorce Act that talks about this, okay? Because I don't want anybody to sort of walk away from this with any misunderstandings about what exactly the nature of the duty is. Section 7.3 says, to the extent that it is appropriate to do so, the parties to a Divorce Act proceeding shall try to resolve the matters that may be the subject of a court order under this act through one of those dispute resolution processes. So it says that when you do this, it has to be appropriate, and it may not be appropriate in cases of family violence. And it says that you're required to try to resolve the disputes. It doesn't say that you have to, right? So if there's an issue about getting access to a mediator or to an arbitrator, well, it may not be appropriate. It may be simply easier to get to court, but I do not see this section being used by the court to kick cases out, right? It'll be used by the judge to sort of wag their finger at you and say, you really should try this, and I really encourage you to do it. But I don't see this becoming an absolute barrier to people getting into court. But on the issue of the supply of mediators and arbitrators, I'll tell you that, life has changed immensely since I first started to practice family law. When I first started to practice family law, every file that walked in through the door was a file that was heading to court. But what we're seeing is a flight of lawyers out of court and into work as mediators and arbitrators. In fact, I can think right now of the vast number of very senior family law lawyers in Toronto, Calgary, and Vancouver who have all hung up their litigation spurs in favor of a career as an arbitrator. So more and more people are doing this kind of work. And I should also mention that in jurisdictions like British Columbia and more so in places like Alberta and Saskatchewan, you don't have to be a lawyer to work as a mediator or an arbitrator, right? British Columbia has legislation that sets out training and experiential standards that you have to meet to work in that capacity, but it's one of the only provinces that does that, right? In other places, you can get anybody to serve as your mediator or your arbitrator. And in fact, there's also processes that are completely outside the court system, such as fairway divorce, which offer another kind of process for wrapping up your legal affairs. So there's more and more people providing this kind of work, and I'm not really concerned about lineups. Where you do see lineups in terms of getting access to a mediator or an arbitrator are to the mediators and arbitrators who are at the very, very top of their profession. Those people can sometimes be extremely difficult to get into, and which isn't such a bad thing because they usually come with extraordinarily high hourly rates. So it's not such a bad thing.
Fabulous. Thank you so much, JP. JP, I've got one last question. We're really coming close to the end of the hour. So we're going to do this last question and then we'll wrap up. Here it is. With respect to mobility relocation applications, Gordon v. Gertz laid out the factors to look at. I have two questions. Number one, are we supposed to just forget about the factors laid out in Gordon v. Gertz? And two, the amendments to the legislation seem to incorporate the same principles, but in less factors. How do we approach this in our legal argument, given that we don't really have any case law under the new provisions yet?
Well, this question sort of raises philosophical concerns about the relationship between the legislature and parliament and the courts. And the answer is, we don't yet know. The Gordon and Gertz factors that the person asking the question refers to come from that case I've been talking about a couple of times, right? And what the legislature has done, Parliament has done, is it's codified some of those factors and tried to tweak it to provide something that smells a little more certain than the current state of the case law that has developed following Gordon and Gertz. I think that Gordon and Gertz will still be relevant, and the cases will that follow it, in terms of interpreting the Divorce Act factors that are similar to the factors expressed in Gordon and Gertz. But the interesting thing, the philosophical part of this, is about the extent to which Parliament kind of throws something at the wall and sees if it sticks. So, like, for example, remember when I was talking about the shifting burden of proof? Well, there's two brand new phrases: substantially equal parenting time and vast majority of parenting time. Neither of those terms are defined anywhere in the Divorce Act or in the Federal or Provincial Interpretations Act. What does vast majority mean? I don't know. It has to be something greater than a simple majority of 50% plus one. But what does substantially equal mean? Well, we know what equal means. Equal means 50%. And if we're talking about shared parenting under the child support guidelines, well, that's 40%. And we know how to count to 40%. We didn't always, but we do now. But the Parliament made a choice. It didn't say shared parenting as defined by the child support guidelines or equal parenting time. It said substantially equal. What that means is that we're all going to have to keep throwing things against the wall until we find out what sticks. It took years for that shared parenting principle under the child support guidelines to be resolved. We would argue about things like, well, 40% of the child's time. Well, who gets credit for the time when the child is sleeping? And I'm not kidding. That was an argument people made. Another argument was, well, the child's at school, not in my care, not in your care. Who gets credit for that time? And we argued about this stuff. But about 10 years after the child support guidelines came into effect, we kind of figured it out. And we stopped arguing about how to count to 40% because there were enough cases and enough guidance to help us figure this out. Unfortunately, the relocation provisions of the Divorce Act are going to be pretty much exactly that. We have to figure out substantially equal parenting time. We have to figure out vast majority, and we have to figure out how all of those individual factors that are specified in those sections are going to play out. And as far as we're concerned, if you can find legislation in the case law that is similar in sound and in flavor to the new tests under the Divorce Act, well, you're going to be hauling that out and using the principles in those cases to argue your point. But is there any certainty about this? No, not yet. Call me in 10 years, then we'll know.
Thank you so much, JP. That's really helpful. And JP, thank you so much for joining us today and for sharing your wisdom, your knowledge about the changes of the Divorce Act and family law more generally. And before we say goodbye, is there anything that you'd like to say before we go?
Well, thank you very much to the People's Law School for putting on this program. The People's Law School has been around since the early 1970s, and if I remember correctly, it was founded by a bunch of enterprising and socially minded law students from the University of British Columbia. And here you are, still at it, 50 years later, doing excellent top drawer public legal education work like this. So huge thanks to the People's Law School for organizing this and putting it on. So thank you very much, Paula, and thanks to Drew and everybody else at People's Law School.
Super, and thank you so much, JP. It's because we are able to bring in first-rate speakers like you to help share that legal information. So a big thank you for taking the time to do today's webinar and for all the prep time leading up to it. We really appreciate it. So thank you.
My pleasure. Thanks very much, Paula, and thank you, everybody. Bye-bye.